which really would mean the involvement of over 6 crore people. Definitely something that needs looking into urgently. However, owing to various reasons which could be unnecessary delays due to the absence of the judge or the parties concerned, cases are known to have dragged for over 15 years.
Especially where criminal cases are concerned, this could involve the lives of people. One such case which has come to the forefront recently has been the Upahar case, where the presiding judge has been transferred and his successor has stated an intention to hear the case all over again. We'll come back to speak to Dr. Abhishek Singhvi, who is the former Additional Solicitor General of India. But first, let's take a look at this report. 31 months after the tragedy that shocked the nation and 1 year after the hearings began, the Upahar case, in which 59 people died in a fire in a cinema theatre in the capital, is back to square one. It took a year and a half for the Metropolitan Magistrate to commit the case to the Sessions Court. Charges are still to be framed against the accused party, and all accused are out on bail. And there could be further delays. The judge hearing the case has been transferred, and his successor has stated an intention to hear some of the evidence again.
When a judge is transferred, you don't start recording the evidence fresh. It doesn't happen normally, unless it's an exceptional matter. Otherwise, evidence is going on, the judge is transferred, you start from the same stage.
The Upahar case is not an isolated one. The backlog of cases, the inefficient presentation of evidence, witnesses turning hostile, lack of public prosecutors, shortage of judges and courts are some of the reasons that keep thousands of cases in this country pending.
If the Law Ministry takes the initiative to increase the number of public prosecutors, to increase the number of courts, and also to provide the full facilities to the public prosecutors to conduct the cases, even the public prosecutors are not provided the basic facilities and amenities.
For the last 4 months, we have been listening that some of our judges who are in the lower court in higher judicial service are being elevated to the high court, so that the other judges will come to their position, and in place of those judges who come to the higher court, the other judges will be recruited, but that matter is being prolonged.
One major cause behind the unnecessary delays of criminal cases is the lack of a specified time limit within which a case has to be heard, making adjournments a common feature.
Time limit have been laid down by the Supreme Court in number of judgments. But in spite of that, there is a lot of problem which is coming in between. Sometimes the defense lawyers, they delay. Sometimes the police is not able to produce any witness. Sometimes a government official is transferred. Sometimes police officer is transferred. Sometimes a doctor is not available, is not able to come before the court. So these delays, they prolong the trial.
Trial delays have in many cases often resulted in the accused languishing as an under trial for a term longer than his punishment. To avoid this, legal experts believe that cases should be prioritized and petty offences dealt with separately.
The government have to change their attitude. They must say that in a trivial matters like a thief, like a small petty matters, small accident matters where somebody has suffered small injury, you don't have to have a trial for 2.5 years or 3 years or 4 years. These type of cases, things should be sorted out of the court settlement, like in other part of the world. They have, on the very first day of hearing, they say, okay, you pay this much money, you're out of the criminal case. If we have that kind of an attitude, I'm sure that half of the criminal cases will go out. And the rest of the cases, they can concentrate much more. The police can spend much more time in investigating and solving those cases.
After all, justice delayed is justice denied. And to discuss this, we have with us this morning Dr. Singhvi. Morning, sir. Welcome to the studio. To just get focus on this issue, the Upahar case. This is not the first time a judge has been transferred in such a high-profile case. What are your views?
There is absolutely no requirement, legal or otherwise, that in a case of a transfer, the trial has to start de novo or from an anterior stage. So therefore, unless there is some pressing particular reason, the trial could continue from the stage at which it stopped. But the other side of it is that there is in place no management system, no data system, no technique to know that when you exercise the administrative power of transfer, at that point of time you have sufficient material to show that the transferee or the proposed transferee is having so many cases of this degree of seriousness at such and such stage, so that you pass a general transfer order without being aware of the roster of the judge. Therefore, this is more a management failure. It's more a data failure than even a legal failure.
But what about the reasons for the transfer itself? You know,
well,
are they valid? Is there any system to judge whether it's reason enough?
The transfer is really an administrative power. It is not supposed to be related to the judicial exercise of judicial power by the judge. Transfer is an incident of his service. If he is promoted or if he is otherwise, after 2 or 3 years in a particular slot, required to be moved, then he is moved.
But
It is done without reference to the matters he is handling.
It's likely to happen because the cases drag on for so long.
Absolutely. I think from cradle to grave, so to say, or from initiation to acquittal or conviction, there is hardly any case which has seen a single or even 2 judges. It would have seen a very large number of judges. And that means discontinuity.
Transfer is just one of the issues. Like transfers, there are many other issues in terms of non-appearance of the parties concerned, adjournments, prolonging tactics, which are normally referred to. What is the overview on this? What's being done to address these?
Yes, I think transfer is only symptomatic. It is part of the larger problem. And I think the larger problem, bluntly stated, is that perhaps the criminal justice system in India is breaking down, if it is not already broken down. It has violated the basic social compact between the government and the citizen, whereby the citizen is obliged to provide law and order, a secure environment. Today the tragedy is that any criminal can rest assured in the fact that if a crime is committed, it will either go undetected. If detected, it will not lead to arrests. If arrests are effected, it will not lead to trial. If trial starts, it will not lead to a result of a conviction or acquittal within a time period. And even if that happens in rare cases, it will not lead to punishment. So at each of these 5 stages, there is a failure of the system. And the problem is really multiple. There is a lack of judges. There are a large number of vacancies in the lower judiciary within our already small judicial system.
So what is being done about that?
A lot of proposals have been talked about. Reports are available. The solutions are known. It's a question of implementing the solutions.
So who is accountable for that?
Well, in the ultimate analysis, 2 areas. One is the supervisory judicial branch itself, because in the lower judiciary, the supervision is exercised by the high courts. And secondly, the administrative side, the law ministries of both the states and the central government. Because, for example, things like appointing more judges in time, or ensuring that transfers are done on the basis of particular proper data, or for example applying ADR, alternative dispute resolution, which is normally something applied to civil matters, but in a proper manner can be applied equally to criminal matters. A large number of our petty offences, traffic and other related, should and could be decided by a lay magistrate or by a separate group of persons, and the judicial time today spent on, let us say, offences carrying less than 3 months or 6 months ought not to be spent. They should be taken up, they should devote their time only to more serious matters.
Now tell me, you referred to the systemic problems and some of the solutions that have been discussed. Now, implementation requires resources. What about that end of the problem? Do we have enough resources to get these off the ground quickly?
There is already a Supreme Court judgment in the All India Judicial Officers case which requires a provision of sufficient infrastructure to our entire lower judiciary. You're absolutely right. Today, if you go to the district courts, you have problems, what to talk of computerization, you have problems of clean office environment, lack of filing cabinets, lack of chairs, tables, proper transportation facility for our judges, libraries. These are things which are basics. These are not, these are in the category of necessities. The Supreme Court has already directed that this has to be provided. There is now a report of a National Judicial Pay Commission to bring a certain rationalization in the structure of hierarchy of lower judiciary and their pay scales. So we have now the impetus, the momentum, and also the answers. But ultimately it has to be implemented within a time-bound schedule.
But what about the quality of human resource? The people who represent the system?
That ultimately is the cutting edge, and that's the sort of bottom line, and that depends on appropriate, proper recruitment. Take an example of public prosecutors, for example.
Absolutely.
They are given a very high pedestal place in our system. There is a section in the Act, criminal justice system, which says that the sole decision about whether to prosecute, how to prosecute, when to withdraw prosecution, etc., is all vested in this PP. And the Supreme Court judgments have elevated that status in theory to say that he is the sole repository of that discretion, and you cannot, even the minister or the top police official cannot direct him in any manner. But in actual fact, unfortunately and sadly, we know the material all over the country. The material of persons or the quality of persons is sadly not up to the mark, neither in terms of competence, nor in terms of ability, nor in terms of independence and objectivity. And that really is a question of how you recruit them, how you choose them, how you select them.
And has there been anything done about that in the past?
Well, there have been recent talks of creating a Department of Public Prosecution on the lines of the English system, or something akin to a district attorney's office, which would be a more independent prosecuting agency. I think it's a move in the right direction, and along with the CBC, which has an independent status, a Department of Public Prosecution supervised by an external high-powered body would be an improvement. But again, you can create institutions with different names, with different compositions. It depends on how you man them. And at each level, you need, in the districts, not only in Delhi and the big metropolitan towns, but in the districts, you need such a prosecuting agency. So the department has to be supervised very closely. But I think it would improve things if such a department was created, but supervised and headed by an external body of a very high-powered nature.
Dr. Singhvi, in the final analysis, with so many high-profile cases that hit the headlines, that some of which obviously both in the criminal and the civil sector do not meet adequate resolution, what's holding the system back? What's taking so long?
Well, I think, as I said, when I say the criminal justice system is breaking down, the sad truth is perhaps that unless you are an extremely resourceful victim, or perhaps a very poor accused, you don't get a conviction or an acquittal within a time. And in most cases, whether high-profile political cases or other cases, people get off. I think some changes in the law are also necessary. A simple but effective example is this whole issue of statements to the police, what are known as 161 statements. It is well known that a statement given shortly after the incident is normally true, but it is equally well known that in law it is retractable, inadmissible and not conclusive. Therefore, it is not worth the paper it is written on. Now, it is easily possible to amend the law and to say that your statements at the initial stage be recorded with a sufficient degree of safeguards, for example, before a magistrate or video recording or audio recording, but that they shall be conclusive and admissible and usable. Because hostile witnesses, retracted statements have become the order of the day. Virtually no trial, howsoever delayed, delay is one problem, but one would even live with delay perhaps if at the end of the delay you came to a result, one way or the other. But that result itself is not achieved because of this.
Basically what we're saying is, somewhere along the line we'll have to put the money where our mouths are. Well, let's hope it heads that way. Thank you for being with us.